This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. This blog post 4673 deals with the fact that if you have no sprinklers, you have no coverage because there is a breach of a condition precedent, which, if you do so, will defeat your coverage and eliminate any right you might have to the benefits of the policy. The plaintiff was unhappy learning that and appealed the trial court's order granting summary disposition in favor of the defendant in a case called 23-771 Blackstone LLC versus Conifer Insurance Company, a November 16, 2023 decision of the Michigan Court of Appeals, where the plaintiff sought to avoid the fact that it breached the material condition requiring it to maintain a fire sprinkler system as a protective safeguard. A fire had occurred at plaintiff's building in Warren, Michigan. The building housed a marijuana growing operation. Defendant insured the property against fire and other hazards under a commercial property insurance policy that defendant originally issued in 2017 and renewed annually thereafter. The parties did not dispute that defendant's policy included a Protective Safeguards Endorsement, which provided in pertinent part that as a condition precedent, the insured was required to maintain the protective devices or services listed in a schedule. The protective safeguards to which the endorsement applied was an automatic extinguishing system. After the fire, plaintiff filed a claim under the policy, but defendant denied the claim because the property did not have an automatic extinguishing system. Plaintiff sued, alleging that defendant had repeatedly inspected the property and was aware, or should have been aware from the inspection and other sources, that the property did not have an automatic sprinkler system. The insurer moved for summary disposition, arguing the policy language was clear and unambiguous, and that because plaintiff did not have an AES on his property, it was precluded from recovering fire protection benefits under the terms of the policy. Plaintiff, faced with an obvious failure of a condition, responded that the defendant should be stopped from denying coverage for lack of an AES because the PSE was ambiguous since it did not actually define the system. The trial court ruled the insurer was entitled to summary disposition because the policy unambiguously precluded coverage if the insured property did not have an AES, and it was undisputed that there was no AES on plaintiff's property. Initially, plaintiff had argued that the language of the policy was ambiguous and it should be construed against the defendant and in favor of coverage because it didn't define what an Protective Safeguard Endorsement was, but in fact, the policy provided a definition of an automatic sprinkler system, stating that it means, quote, any automatic fire protective or extinguishing system, including connected 1, sprinklers and discharge nozzles, 2, ducts, pipes, valves, and fittings, 3, tanks, their component parts and supports, and 4, pumps and private fire protection mains. When supplied from an automatic fire protective system, non-automatic fire protective systems and hydrants, standpipes, and outlets, close quote. Clearly, what it was they were required to produce was set forth in the policy, and that argument failed without any problem. Accordingly, the court concluded that the Protective Safeguard Endorsement is not ambiguous because it adequately explained the meaning of an AES. Plaintiff asserted that the AES requirement should not bar coverage for its fire loss because both it and defendant were fully aware that an AES did not exist at the property. Plaintiff was aware because it owned the property, and defendant was aware because multiple inspections revealed that there was no AES on the property. However, the mere fact that the defendant and plaintiff may have been aware that the property did not have an AES does not establish that the parties mutually understood and agreed that an AES was not required as a condition of coverage. In fact, the opposite was true. The policy unambiguously required that the property have an AES as a condition of coverage, and there was no evidence that the Defendant Insurance Company ever intended or agreed that an AES was not necessary. There was no evidence of a mutually shared factual mistake by the parties regarding the impact of not having an AES at the property on the availability of coverage. In my opinion, we must always remember that insurance policies are contracts. The contract agrees to indemnify an insured against multiple risks of loss, but never every potential risk faced by the insured. When an insurer requires protective safeguards like fire sprinklers or burglar alarms, it reduces its premium because of the fact that the risk of loss is lessened by the protective safeguard. Failure to maintain a protective safeguard, a condition precedent, eliminates coverage because the risk of loss was not as promised. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you will receive notice of every blog posting, usually 5, sometimes 6 a week, and you will also gain access to the more than 4,700 blog postings. If you enjoyed or found useful this blog, please tell your friends and colleagues so that they too can subscribe to the blog, or as you and they could subscribe to the videos on YouTube and rumble.com. And if you like the videos, please click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publications or my Locals community. Thank you for your attention.